And I'll give an example for the people that are here. This nice lady, a member of the legislature, has passed a law after going through the House, the Senate, and the governor that red ties are illegal. I'm now wearing a red tie. So what's going to happen? The legislature has no power to enforce that, even though this nice lady in her act of Congress passed this law. And quite frankly, the court can't. The court can say, Mr. Delaney, red ties are illegal, you cannot wear that, but the court has no enforcement power. But that's not the case with this gentleman here, who has a firearm. And we appoint that to the executive branch so they can enforce the laws. He can immediately enforce this law, but that is the only power that he has. He doesn't have the power tomorrow to make blue ties unconstitutional or red ties or change his mind. And so each has their powers. But Madison was very good and generous to the people. I still can come back to this court, the judicial branch, and argue that the red tie law should never have been enacted by the legislature in the first place. But what happened during COVID was that all changed. The non-delegation doctrine, as the court is aware, does not allow the legislature, this nice lady, to give her law-writing power to this nice gentleman in the executive branch. The non-delegation doctrine restricts that by saying what are the standards, what's the scope, and what's the duration. The intelligible principle, which I'll come to later. But there's not only delegation, there's usurpation, which simply means that the executive branch found a law that they think applied to them and allowed them to write law. They weren't given that power, they took it. That happened in October of 2020. Most of the people in this courtroom remember what it was like during COVID in the state of Michigan. COVID tested James Madison. And in the in-re certified question, the governor was acting under power given by the legislature to the governor to write laws. And every day that we woke up, whether the governor was a Republican or a Democrat or a Libertarian is irrelevant to me. But the standard for the governor was anything reasonable and necessary. That was it. See, the definition of a law is it must be a law when it leaves the courthouse, the Capitol. If the law is 75 miles an hour, that's the law. The sign can't say reasonable speed as determined by the executive branch. But that went on for months. And you couldn't visit your second home, you couldn't have motorboats. Those are all fine if they come from the legislature, which they did not. So the Michigan Supreme Court struck down the governor's power. In fact, they eradicated the entire act. It did not end there. The governor then pivoted to the health department. And the legislature, perhaps unwittingly, had written some laws that allowed the legislature, allowed the health department in the executive branch to write laws. And those mass mandates came right back. In fact, they came back over the weekend. Fast forward to January of 2022, the Iron Pig restaurant refused to comply with the executive branch orders. They lost their liquor license, they lost their food license, they also had court-ordered mandates from Lansing to close their restaurant under threat of jail. We appealed that decision to this court. On January 13th of 2022, the court looked at the law and said, the standard is this. If there's an epidemic, which isn't defined, and whenever necessary, the executive branch can issue an emergency order to prohibit the gathering of people for any purpose. Extremely broad language. And the executive branch ran with that. They closed restaurants, you had to wear masks, you had to social distance. The court struck down that law under a case of 1803 called Marbury versus Madison. Yes, that's the same James Madison. That gave this court equal co-branch power to strike down laws of the legislature that were given to the executive branch. The court also indicated in that decision that there are other statutes in the health code that will suffer the same delegation of laws. Epidemic is undefined.
The court say that they may suffer from the same.
Yes. Okay,
but I declined to analyze the statutes because they weren't before.
The court said so they may suffer from the same fate of delegation. But the court indicated that vaping, for example, could be an epidemic, but it's unexercised but available power. So what happened next? So that's January of 2022. In December of 2022, the Court of Appeals decides the Holmes versus Ottawa case, which was the Ottawa Health Department on the west side of the state. And in that case, they did not look at the non-delegation doctrine. They They simply read the statute as is, as given by the legislature to the executive branch, and said that an unelected health officer, an employee, can tell an elected board of commissioners what to do. And that's true, the law does say that. So the employee trusts the elected organization, but the people have no power there because the person is an employee. So that court said that it's not moot, which is important because I expect the health department to argue that this case is moot. But that published case in December of 22 said, look, the mask mandate has been off the books, COVID is over, we are still going to decide this case because some type of emergency order in the future is likely to recur. So they decided the merits.
Well, let's look at this case, because you cite 5 different statutes that you're asking me to find violative of the non-delegation clause, correct?
Correct.
2453, 2451, 2455, 5201, and 5203.
Correct.
Which of those statutes were cited by the department with respect to any of the challenged actions or the closing of the Arabic restaurant?
2453 and 2451. And you'll find attached to my complaint an order from the health department.
From this both on 2253 as well as the local health department?
That's correct, yes.
And so it's your argument then that because those statutes, even though 2253, at least by my order at circuit court level, was excised from the statute, those still are affected and still potentially could be implicated against Arabic in the future if there's a new pandemic.
That's correct.
Or